Supreme Court of India James Kunjwal vs State of Uttarakhand and another decided on August 13, 2024 SCC Online SC 1943 Facts of the case. The appellant was made an accused in FIR under sections 376 and 504 of IPC. His bail application was allowed. The complainant sought cancellation of such order of bail. High Court dismissed the application for cancellation of bail and observed and directed that the appellant had intentionally filed a false affidavit before the court. A complaint under Section 193 of the IPC was to be filed before the Chief Judicial Magistrate. The observations and issued directions, now the subject matter of adjudication in appeal. Findings of the court. The short question that falls for consideration of this court is whether the contents of the affidavit filed before the High Court, as taken note of in the impugned order, constitutes an offence under Section 193 IPC. As defined in Section 191 IPC, the three essential factors which can be said to be sine qua non for the application of Section 193 IPC: false statement made on oath or in affidavits, that such statements be made in a judicial proceeding, such statement be made before an authority that has been expressly deemed to be a court. The court should be of the prima facie opinion that there exists sufficient and reasonable ground to initiate proceedings against the person who has allegedly made a false statement. Such proceedings should be initiated when doing the same is expedient in the interests of justice to punish the delinquent, and not merely because of inaccuracy in statements that may be innocent/immaterial. There should be deliberate falsehood on a matter of substance. The court should be satisfied that there is a reasonable foundation for the charge, with distinct evidence and not mere suspicion. Proceedings should be initiated in exceptional circumstances. For instance, when a party has perjured themselves to beneficial orders from the court, the statement made by the appellant that has been deemed to be befitting the offense of giving false evidence before the court, which is known commonly as perjury, was more in the nature of denial of the statements made in the affidavits of the complainant. Herein we are of the view that, in the present facts, a denial simpliciter cannot meet the threshold, as described in the judgments above, particularly when no malified intention/deliberate attempt can be understood from the statement made by the appellant in the affidavit. As has already been observed, mere suspicion or inaccurate statements do not attract the offense under the section. It cannot be disputed that the statements made in the affidavit were only to state his version of events and/or deny the version put forth by the complainant. We find that at least three of the possible scenarios, as discussed supra, in which a court would be justified in invoking these powers on the face of it appear to be unmet. Prosecution, therefore, would be unjust. We say so for the reason that the respondent in her counter-affidavit filed before this court makes no particular allegation, nor does she provide any of the material that was allegedly placed before the competent prosecuting authorities or the court consequent to the above discussion. We set aside the direction of the High Court. The appeal is, accordingly, allowed.